Welcome everyone to April's Lunch and Learn. My name is Devontae Roche. I work alongside Linda with sentencing guidelines. Today we are going over. Today's going to be an open Q&A, and we're going to go over out-of-state offenses and some outliners when it comes to that. So, on the beginning of this Lunch and Learn, Linda's going to do a presentation. Afterwards, we will have an open discussion with Q&As. At that time, I will unmute everybody, and then you can either put yourself on mute if you don't have anything to say, or raise your hand if you would like to say something, and then we'll be able to call on you, or then you'll be able to unmute yourself, and you can ask your question. All right, so let's get started and have a great lunch and learn, everyone. I hope everybody has some good food to eat too while we learn a little something. All right, Linda,
All
whenever you're
right.
ready. Yeah.
Well, thank you, Devontae. What an interesting lunch and learn we have today. This is the first time we've ever done an open Q&A session as opposed to having like a very central topic, and we're going to only talk about that. That is the case here. However, this is a lot broader than we can just do some slides and let it go at that. So what I want to let you know is that we are recording this, and we do have the PowerPoint that will drop into the chat. If you want to ask a question, totally 100% ask, but let's keep any sort of demographic information out, like a case number or anything like that, just so that we can keep recording so that everybody can take full advantage of all the questions and answers. One of the things that made me really excited about today was the Johnson case, and sort of from a very egocentric position. Wow, I've been saying all of this for a long time. And so it was really kind of nice to be validated. However, my opinions mean nothing on this topic. The people that have the opinions on this are the district court, the appellate court, and the Supreme Court ultimately. And so the thing I want everyone to always remember when you're starting to work on out-of-state offenses, get rid of the where it came from. Doesn't matter where it came from. What matters is what they did and if and how that would translate to an offense here in Minnesota. So it doesn't matter if in Arizona they committed this specific offense and they went to prison. Doesn't matter. We need to use that as though it had occurred here in Minnesota, and then did it receive a sentence that was appropriate to a sentence you would receive here. And so that's why we say all of the policies that you apply to Minnesota offenses, you also apply those to out-of-state offenses. And I do use the term out-of-state and non-Minnesota interchangeably, so they mean exactly the same thing. But when we're working with these kinds of things, I find that the position, and I'm not sure who's on the call today. I'm looking at the names and I'm recognizing a lot of probation agents, which is amazing. I don't know if there are any attorneys on here, but I will tell you, as we tell everyone, we're not attorneys here at the sentencing guidelines, so we can't interpret statute. Whether we think we can or not, it's not the position of the sentencing guidelines to interpret behavior in another state and equating it to here in Minnesota. That always has to go through the district court. But there are times when there are offenses that we can look at transferring over and finding some information that we could provide as a starting point to usually the prosecution, because every single one of the court cases that have come out all the way back to my earliest one, I think in 2002, 2003, Molly, which really laid the foundation for all of the published and unpublished cases that came after it, was the idea that the state bears the burden, the state being the prosecutor. The prosecutor is its own entity, away from the defense, away from probation, but they're the ones that have to go in and prove. So I think when we can provide information to them that might be helpful in saying, okay, we have this drug offense from, I'll use Arizona, I always do. We have this drug offense from Arizona. We know that they sold cocaine according to the complaint. So if they committed that same offense here, it would probably be at minimum a third-degree controlled substance offense, because cocaine is a narcotic, and sale of a narcotic under third degree has no threshold. You don't get a threshold on narcotics until you hit a second degree. And so that is something that you can say, okay, it appears that it would be equated to a third degree. Please verify. That's being helpful without being factual, if you will. This is a third degree. Always using the language "this appears to be" is a safety net, I feel, whenever we're trying to explain this out of state stuff to the prosecutor, to whomever is asking. But one of the things that I find most frustrating, and I know that you do too, is when all of the burden is put on probation to make all of the decisions about how the out-of-state offenses relate to, and then you also bear the burden for gathering up all of the information, which under the rules of court, certified copies are required. Okay. All of that being said, much like we kind of do in the waiver situation where we say, we don't know whether or not this custody status can be waived if this defendant is eligible for that. But here are all the ways you can't waive the custody status. So I feel like sometimes coming at these things from, here are the offenses that just absolutely don't have a correlation to something that is usable. That is still jumping off the side of a cliff and hoping the parachute opens. But at least it's saying, I'm trying to do this. And I feel like after the Johnson case, trying to do this might be a little easier, because the answer is always possibly no, we don't have any information on this. Here you go. I'm sort of rambling, and I'm sorry. This is just a topic that I could drone on and on for, obviously, but I want you to keep in mind the difference between the offenses that are potentially able to equate and the offenses that you don't want to touch. And I feel like when you've got those offenses that you can equate, those are going to fall in that arena of a threshold offense or a monetary offense, where Minnesota makes it very clear that these are the parameters required for someone to be charged with this offense here in Minnesota. And so we have minimum thresholds for theft offenses or other type of monetary offenses, as opposed to having maximum thresholds. So you have to be really careful if you see an offense from another state that says offense not to exceed $10,000. You really need to know what the amount of that was, because although that seems, boy, awfully broad for us to have, how much is this actually going to be? I'm sorry, I have to step back a second. I was confusing myself there. I'm sorry. Okay, so when we have a threshold offense, like a monetary offense, you've got to know the amount of the offense. That's what I'm trying to say. You have got to know the amount of the property theft. Don't take into consideration anything like fines, anything like restitution, anything like that. It is the hard basis of what the amount is. Because when we see something like $250 to $5,000 as the threshold that the other state has, that's anywhere from a misdemeanor to a gross misdemeanor to a low-level felony. We don't know what it is when we don't know the amount. With drugs, we need to know the amount, and we need to know the type of drug and what they did. Pretty much just straight sale or possession, because that's, again, how Minnesota does it. We know exactly how much sale or how much of the drug you have to possess in order to be charged at that particular level. But even with that information, even if it's very clear, let the court make the final decision. Let the court always make the final decision. And I think the best practice is, until you know for certain that any out-of-state offenses that are going to be used are potentially going to be challenged or have not, the state has not met the burden on them, they should not be included on the worksheet. It shouldn't be a situation where they get included until they come off. No, they should not be included until they're deemed eligible to be included. And that's about the only hard and fast rule, or not opinion, that I can give to you, is that I think you're just going to run into a lot more if you use them and then wait to be told otherwise. I think leaving them off and notifying the parties that these offenses are not included in criminal history until as such time as probation is made aware of their eligibility. Within the realm of 2B1 through 2B7, those are our criminal history policies. Just to mark a couple of those as slightly different, when you have a juvenile offense, they have to follow all of the rules in Minnesota. They have to be over 14 when the juvenile offense occurred, under 25 when the Minnesota offense occurred. It has to be a felony level offense. And the last one, it has to be adjudicated delinquent in juvenile court. So those 16 and 17-year-old kids that go to adult court for felony level offenses are not automatically going to be used in the juvenile section because they were under 18, nor are they going to be used in the adult section because they're under 18. Any juvenile offenses that are dealt with in adult court are ones that are certified. And so that's what the decision State v. Marchetti said way back in 1982, that if a juvenile offense is treated in adult court in another state, the district court in Minnesota must decide if that was an offense that they would have been certified for. And Marchetti makes no reference to EJJ. So I think certification is the hard word there to stick to. So always make certain that when you're using offenses in the adult history, that they were at least 18 when they committed that offense, so that you know you're looking at a true adult offense. and those out-of-state offenses you want to use in the juvenile section, you've got to look for that adjudicated delinquent in juvenile court to make certain they fit those policies. And then the other outlier policy that we have relates only to federal offenses. Federal offenses that were handled in federal court that have no equivalent here in Minnesota, those get 1 point. But that is only federal offenses. So any international offenses, any military offenses, things like that, that were adjudicated within that jurisdiction, those have to equate just like if it was an offense from Arizona or Tennessee. You can't just automatically use them. The only ones that are automatically going to go on the worksheet one way or another are federal offenses. But even within all of these, you might have them match up to a felony and say, okay, this is good. I can use this as a felony. But you've got to look at the sentence. You've got to always let what the offense was lead whether or not it is equitable. And then use the sentence to determine if it is equitable, where it goes in criminal history. So rather than coming from the other side and saying, oh, okay, well, they got 2 years in prison for this, but guess what? It was a burglary of a motor vehicle. And you know what? We're going to have a little bit of an issue here. The doorbell just rang in our office, and I think it's our water delivery. So I'm going to keep talking while I let these people in. Go ahead. I'm on a call, but go ahead and just, okay. So we have a water cooler here at MSGC, and we have to get it filled with bottles that get delivered. When you're looking at the sentence is always going to come second. First, you equate it, and then you look at the sentence and you say, okay, once we find where it goes, we use the sentence to equate it, or excuse me, to put it in its proper place in criminal history. But remember that the commission kept 366 days as a minimum felony sentence for a non-Minnesota offense. And that was so that those offenses, especially in our border states, that are felonies that get 365 days, that we have always been using as gross misdemeanors when they equate, that we keep that policy so that as not to take all of those offenses that we used to call gross misdemeanors and suddenly they're now felonies. So whenever we're looking at that sentence, we have 0 to 90 days for the misdemeanor, 91 to 365 days for the gross, and 366 days or more for the felony. And they have to be an imposed sentence. So we're not looking at the amount of jail time they got. We're looking at an actual sentence. It might be stayed and given some kind of conditional jail time. It might be executed to prison. We're looking at that duration. But we do have situations, especially in Wisconsin, where we see terms like sentence withheld. When we see sentence withheld, we can usually go ahead and say those probably count because we'll probably find a conviction. And that's what we're looking for in those situations where we don't see an imposed sentence. Let's look and see if we have a conviction, because you can have a conviction and have no sentence imposed. That's perfectly logical. But you can't have any kind of sentence without first having a conviction, which goes beyond the guilty plea. It is just strictly that there was a conviction on it, and then you see probation and you see jail time. Perhaps conditional jail time. That's potentially our stay of imposition. But I always like to say potentially because the court may want more information on that. You know, what was the conviction? How did that work? Et cetera, et cetera. And so getting really familiar with Minnesota policies is so helpful in understanding how to apply out-of-state offenses. Remembering also the responsibility of probation is to follow the guidelines in creating that sentencing worksheet. And if you are not given any information, if no one responds back to you about any out-of-state offenses you're trying to correspond on, don't include them. Leave them off. That is the most appropriate action to take. And if they ask you where they are, you can say, here's the email that I sent and I did not receive any information back. So under State v. Johnson, I left them off. I know that I'm rattling on and on here. I apologize. This is a big topic, and I know this is a struggle sometimes, and I dislike it when it is a struggle because it should be fairly straightforward, but nothing about the guidelines is straightforward, it seems sometimes. So I just wanted to give you a piece of what all of these court cases have been. And it started back with Molly in 2006, where it just quite simply said the state did not establish substantial or sufficient factual basis for those offenses to be included. And Keltner, the next one down, that was one that really talked about not only do these offenses have to be equitable to an offense here in Minnesota and received a Minnesota sentence, Keltner almost took it down to a micro level where it was, okay, this offense, sure, it equates, but is this the person who committed that offense? Is this the person that was sentenced for this offense? Do those line up as being the same person? And so Keltner also talked about the ability to provide all of these official certified court records. And I would say when they are available, that is a really, really good thing to have, but they are not always available. And so there was another case, I think, that is helpful, and it was not a published case, but basically what they were trying to say is to justify the facts required to justify the district court's inclusion of the out-of-state convictions in criminal history score by greater weight of the evidence. So you could include them because the greater weight of the evidence said that it was more convincing that the evidence would lead a person to believe that the claim was true as opposed to not true. So the evidence that can be provided, and it talks about in the Johnson case, it talks about how the probation was testifying not as a sworn witness, but as an officer of the court. So do you see all of these things that are wrapped up in it? It's confounding to me sometimes how we figure this out. How do we not have a reasonable system nationwide that allows us to look everybody up and we've all followed the same rules and everything is good? We just don't have that, and that's okay. So I just want to let you know that with respect to out-of-state offenses, I think I've made it perfectly clear. The state bears the burden. The state bears the burden, not probation, not defense. Defense is going to argue it, but the state, the prosecutor, bears the burden of proving that not only is that crime the same as a Minnesota crime, that sentence is the same as a Minnesota sentence, not a sentence that this crime would have received in Minnesota, but that it meets the parameter of a misdemeanor, gross misdemeanor, or felony. And that the person they're saying did it actually did the crime. So, to get out of all of this case law and this terrible journey that I've tried to go down here with trying to explain, it's really not as difficult, but it's also not as easy as it seems. But the one offense that will always pop up is bail jumping. There's bail jumping in Wisconsin and there's bail jumping in North Dakota. Bail jumping in Wisconsin is not necessarily the same as failure to appear here. Minnesota's failure to appear says you were notified that you were supposed to be in court and you didn't show up. So you can get the failure to appear. In Wisconsin, bail jumping includes not only that, the missing court dates, but it also does things like committing new crimes or breaking rules on conditions of release that the person may have had. And I was up in the 6th district several years ago talking to public defenders up there, and there were a couple of prosecutors from across the bridge in Superior, Wisconsin, and they were there for another thing, but we were talking, and I said, you know, what is the deal with bail jumping? And they said, yeah, we can charge a bail jumping if you get pulled over for having a failing to use a turn signal. You know, it's that whole law-abiding thing. And so bail jumping, failure to register as a predatory offender, these are offenses that you have to peel back away from the current offense that you're looking up, the bail jumping, and see what they did to even get to that place where they could be charged. Minnesota makes it very clear, failing to show up for a felony is a felony. Boom, very clear. Well, missing court dates, violating sobriety, violating no contact orders. So you go through and you find out, okay, they did in fact miss a court date on X offense. Now you have to decide whether or not that offense was an offense that would have been eligible in Minnesota, so that if they failed to show up for it, they could have gotten a failure to appear. There was just it was an unpublished case, which means it only affected that defendant, but they removed a failure to register from their criminal history score because the act that they were required to register for in California was not an offense here. So they did not commit a registerable offense here in Minnesota, so they would not have been able to be charged with failure to register. So those are some of the things that you have to do when you see some of these offenses is that have another offense embedded in them. This happened because something else happened. In North Dakota, it's a little clearer and it's fairly close. It's a lot closer to ours. It's a lot closer to ours, but it's also violating conditions of probation, of release and things like that. So always, again, make certain that you look at that you peel back the layers and you look at how did they get to an offense. Failure to register, failure to appear, those are only offenses that you can charge if you had done something else that would lead them to that. What was the something else? That gets really convoluted and really confusing. And so that's why I think that in all of these situations, establishing a really good communication between all of the parties is an incredibly good idea. How are we going to handle out-of-state offenses under the new Johnson case? What is going to happen? There are 87 different counties out there functioning 87 different ways. So all we can do is suggest that you have these conversations when you know initially, if you run a criminal history and you see that there are out-of-state offenses, let the prosecution know right away. You know how to communicate with them. That's something that you all are good with. We don't do that. So you know exactly how to communicate with the parties to let them know what's going on. And that's you doing your due diligence. And that's you following the guidelines. 2B5 says it's the court that determines if the offense is eligible to be used in criminal history. If the court does not decide it, is it still eligible to be used in criminal history? I think no. And that's what the Johnson case said. Just because he didn't challenge it didn't mean it wasn't also the obligation of the state to prove it. All right. I'm going to climb off my high horse that I've been pontificating about this, and thank you for sticking with me. There's a lot of thoughts going on in my head right now, so I would love to turn it over to you, and let's talk about how this happens in the real world, not in the sentencing guidelines world. So if anybody wants to talk about anything, you are open to stick around, or if you feel like you've heard enough, you're good to go. Have a wonderful day and enjoy the good weather today and tomorrow, because my understanding is Saturday and Sunday are going to be very cold. So get some sun while you can. But otherwise, let's talk. If anybody wants to talk, let's talk.
Well, I think we have a good question in the chat. Is regarding federal offenses. If there is an equivalent Minnesota offense and the defendant receives a 180-day jail sentence, this would equate to 1 unit gross misdemeanor, correct? Not a felony point, as it did not receive 365-day sentence.
366 days for the felony sentence on a
non-Minnesota offenses.
Yes.
Okay.
Yeah. The way that we know that a federal offense has no equivalent is because we went looking for the equivalent. And when we don't find the equivalent, then we say, okay, there's no equivalent. The sentence dictates that it goes in the gross misdemeanor section for a unit. So in that situation, I think we would follow what any other felony would do when it's sentenced below a felony level and put it in the gross misdemeanor section. Of course, there's a little more leeway with federal ones because nobody really ever talks about federal offenses in these court cases. But I think starting with that as a misdemeanor or gross misdemeanor unit is a good idea. Whether it was the equivalent of a Minnesota offense or a not equivalent, follow that sentence to where it belongs in history.
Okay. I think there's another one here.
Oh, good.
In the chat. So can we change out bail jumping? We charge out the reason they have bail jumped. I hope I'm reading this question right.
It's in the chat, you said.
Yeah.
So can we charge out?
All
So
right,
we
here we
don't
go. It
charge
got
out.
corrected.
Oh, we don't charge out bail jumping. We charge out the reason they have bail jump. No, the bail jumping is the offense that we're trying to equate, but
Mhm.
we have to go back and see what they jumped bail on, knowing that Wisconsin defines jumping bail as well beyond what I always thought it was just, not showing up for court. But you have to expand that to look at what they did, and did what they do rise to the level of a failure to register. So you have to take bail jumping back. You have to take failure to register back. Certain persons not to possess firearms. You got to take, felon in possession. You got to take those back, but you are using the offense that they were charged with, which is bail jumping. You're just trying to figure out whether or not that would be a chargeable offense here in Minnesota. And this brings up a really good point too. We don't call it bail jumping here, but that doesn't mean it's not the same offense. So that's the other thing that you can sort of set aside, is the name of the offense, and look at the body of what happened. And I think also Googling. I got that information about bail jumping off of Google, and I'm pretty certain the AI bot thinks that I'm looking for an attorney, because it keeps recommending a lot of lawyers to me for these things that I have Googled that it thinks that I have done. But I think I think I've said enough here. I hope. Just know that you're equating it to a Minnesota fence. It's not a name to name comparison, it's an action to action comparison. And federal offenses do have to have 366 days imposed. 365 would be a gross misdemeanor.
We have a question in the chat. I mean, we have a hands up for Tammy.
Yeah, I was going to say, Tammy, you've had your hand up, so please. And then we'll get to the chat question.
Okay, so I have a couple things since I do Wisconsin all the time. Sometimes that bail jumping will also include, like a domestic assault in that same thing, and that's what the bail jumping was. So you can only use one of them, because they'll list
No.
like domestic under bail jumping, and that's actually why they got the bail jumping, was the new offense.
So they committed domestic assault. They're on release conditions after entering. Well, you don't have to enter a plea here.
Like
They're
a
on
probation, like bail
Yeah.
jumping would be like a probation violation, would be the new offense, but it's called bail jumping.
As long as they did something that would get them to, let's see.
Then they typically don't convict them of both anyway, but you wouldn't, because it would be the same offense. So you wouldn't give them 2 units for the same course, it'd be the same exact thing.
Right.
I don't know if that makes
Yes.
sense, but
yes.
Anyway, so then also I've had a lot of issues in my county with the judges and the prosecutors, and I found out that they were not, this new set of prosecutors, they were not running criminal histories.
Okay.
So they weren't even charging accurately, and they would do plea agreements not having a clue about out-of-state information. And so it took me a while to figure out why they kept pulling all my information off of the worksheets. And then this Johnson came out in January. So I did a whole training thing, training packet on it. And they weren't interested in that. And so finally I developed an email that I send to them as soon as I look at the criminal history and figure out that they have out-of-state offenses. And if anybody wants a draft of the email that I send them.
Mm.
I'd be happy to put it in chat or however send it to you, Linda. And that has been working. So
Wow.
yeah, I say, this is basically your responsibility, but in a nice way. And
Yes.
I put, and in bold, I have out of state offense information, and I put as much information in there as I have access to.
Yeah.
And then they have been requesting the information from the other states for the certified copies of conviction and everything. And
Okay.
it has been very nice as long as I remember to do it right away. And because they would just, the one case they took 3 felonies, just took them off. And that's how I found out they aren't even running these records. So
And that
hopefully they're running
is
them now, but at least I'm reaching out prior to me finishing the PSI. I reach out as soon as I read the criminal history. I send them this, and for the most part, they've been responding. Now, that doesn't mean the other state is always going to comply and provide that information, but at least they're trying.
I think eh, sometimes I feel like it's almost like if the prosecutor calls, it's a courtesy, and they'll help them out any way they can.
Yes.
For some reason, anybody else, forget it. It's $50 and we'll fax it to you.
Right.
It's like,
Yeah.
it's so frustrating. But Tammy, my goodness, you have nailed it. I mean,
Well,
that
and I
is
think
fantastic.
at first I was really ticked off about the Johnson case because I thought, oh my gosh, but actually it's what the prosecutor should have been doing this entire time. And now we
Exactly.
have, an appellate case that documents this.
And
And so,
go
but
ahead,
it was like
sorry.
I had to inform them of this, but
Yeah.
I mean, but yeah, I'll send it to whoever or what does it work if I just copy and paste it into chat? It's not
I
very
don't know
long.
if you can put it in the chat or not. Go ahead and try.
Let's
I'm
see.
okay with that. But otherwise, if you send it to our
Oh
sentencing
yeah.
guidelines email. Okay. Oh, did it work?
Yep.
Yep.
That is fantastic, Tammy. Everybody.
So you see like where it says insert state offense statute case number and any details, that's where I enter what I know.
Yeah. Look at that.
So
That is fantastic. And and again, I'm not disparaging a single prosecutor when I say that. If they don't want to do the work, okay. And this is one of the things that I wonder, is the Johnson case going to lead to them just saying, I'll just leave it out. And then we don't have accurate criminal histories anymore. But
yep.
I can't live in that area.
No.
Because otherwise then it would take me all day to review, and Devontae all day to review a worksheet because we were looking everything up. But I don't know. I hope that everybody takes advantage of this. And it's about communication, and this is excellence. I can't rave enough. I'm raving right now.
Thank you. Well, I was so upset because our prosecutor pulled, it was a presumptive commit. The guy admitted he was to prison 4 times in Florida, admitted it was him and everything, and I had all the records. And then I found out that at sentencing, the prosecutor took 3 of those felonies off so they wouldn't have to do a departure and sentenced him to probation. And I said, where did you get that these were not, because then the client told me that they said that I messed up on the worksheet.
Oh.
And I asked the prosecutor, so where did you get the information that I messed up? And why would you say that in court? Well, I ran his criminal history and these decayed. I said they didn't decay because he went to prison.
Right.
And so I was just so appalled that they took 3 felonies off in one case. And, so our county, in my opinion, is avoiding departures and, presumptive sentences just because I don't know if they weren't knowledgeable or they just don't. Well, actually, I do know they weren't running criminal history, so they didn't have a clue.
Right.
Which is a
and
problem too with felony DWIs, domestics, and everything. If they don't have the priors, how do they know how to charge them?
exactly. And I think that one of the things I was thinking as I was reading the case again last night and looking back at the other cases is this going to be the way out of a departure?
Right.
And time will tell. It's
Mhm.
hard to know because when we send off a departure request for departure to a judge and they return it to us with, oh, well, we took these offenses off. There's
Mhm.
never any explanation as to why, and it's not really our place to ask.
Right.
But then the next person copying that worksheet is
Mhm.
missing those. And granted, copying priors from another worksheet is a courtesy to save keystrokes, but it
Mhm.
sure is a good jumping off point to say, wait a minute, something's missing. Yeah. So, and I had an email the other day that was like that. And the blatant question, are they trying to get around a departure here? And
Mhm.
all that Devonte and I would be able to respond to you is, I'm not sure, but if they don't believe that they can prove that these offenses were committed by this person, then they should not be included. And that's all, our hands are tied there. So
Mhm.
but someone actually, I'm not going to read it out loud, but somebody did actually post a very interesting message in the chat, and that I happen to agree with. So I'll leave it at that. But anybody else want to talk about anything? Because oh, I'm sorry, there was another question that I wanted to see. So a 65-day sentence would be a gross misdemeanor. If you have, oh, this is a good one. This sentence 1 to 5 years is no different than committing $300 to $5,000. 1 year is the minimum, which is a gross misdemeanor. But what did they actually serve? So if they say they got sentenced 1 to 5 years and they actually served 2 years, would that be a felony? I think so. But again, I wouldn't want to say absolutely. So I would say consider that a gross misdemeanor, but make note that it did receive a higher, it did receive an actual 2-year sentence, but the minimum threshold was a year. I just think that minimum threshold is a starting point. It's just like 300 to 5,000 and you find out that they stole $3,500 worth of stuff. Okay, you've got a severity level 2. If they said sentenced 1 year to 5 years, if they did anything 366 days or more, that's your felony. So that might be something that you want to talk, that would be good for a prosecutor to just acknowledge that, yeah, they got that. And that's the problem with indeterminate sentencing states is that's what happens. They did end up serving a sentence, which means they did get a felony level sentence if it was 366 or more. So I'm kind of dancing around this one, but I hope you can appreciate what I'm trying to say is the prosecutor should probably make that final determination if they're willing to argue for that being a felony, but otherwise it would be a gross misdemeanor. Tammy put her email in the chat. Anybody who wants access to the packet she was discussing can reach out to her. Good question. It is difficult to tell if a client's sentence was executed out of state and in turn whether that decay is based on expiration based on the way the state's sentence prison time. When you think about expiration, the expiration date is not when they get out of sentence, but when they're completely done with that sentence. And so and I don't want to put you on the spot. If you want to type it in to the comment section, or if you just want to come on voice and tell me, but I think that here's the thing about decay. The decay factor, the expiration date, the disposition date are there so that we know it's not decayed. The calculator behind the scenes will calculate it. But if you take the date, the year the current events occurred in Minnesota, and you subtract 15 years from that, and then you look and say, okay, did whatever happened to this offense in the other state ending happen before that date or after that date? That will be kind of helpful. And then you get as close as possible for the best date. So I think it's kind of a crapshoot there, but it's only when you're looking at something that's really close to that 15 years, where that small change in the date makes a difference with its decay or not. So I hope that's a little helpful for looking at those. But yeah, if anybody has any pointers about that, please drop them in the chat or raise your hand. Yeah, I think that's the best way to handle the potential fluid expiration date. Is it really going to matter so much so? Or can I get it in here because this offense is not decayed at all, and the next person can update it? Maybe they get different information. Confirmation with the state's DOC records and or probation office, I'm assuming the other state, can help you with identifying actual expiration dates and or discharge dates. That's very true as well. Everybody's got a system in every state that keeps track of who's where and when they aren't there anymore. So I think probation, I always feel like sometimes when you reach out to another state, you're reaching out to a colleague, especially if you're going to another probation office. That's your colleague. So hopefully there's that sort of respect amongst colleagues that gets them to help you. Anyway, any other things? This has been a great conversation. We only have 8 minutes left, but we have 8 minutes left. So I also want to open up the floor if there's anything anybody else wants to talk about that's come up that you're finding is a hiccup within your counties. Let's talk about that. But otherwise, I think this got more productive once we opened it up to you guys talking. So that helps for next month when we're going to have an open Q&A about enhanced offenses. So that will be a really interesting discussion, especially because, policies change and we're always using the guidelines in effect when the current offense occurs. But we want to be as solid as possible on those policies. So talking about enhanced offenses, think about what you might want to bring to the table for that. But if there are, another question. North Dakota, Wisconsin drug paraphernalia. We are not charging in Minnesota, but I have a North Dakota charge of 18 months stayed for 18 months. Drug paraphernalia is a petty misdemeanor or a non-targeted misdemeanor if it's a subsequent. And if the prosecutor is not willing to look into it and see, was this drug paraphernalia actually more similar to what we now call our trace cases? That might be good, but usually drug paraphernalia definitely catches. And this brings up a really good point, if I might make it really quickly. Please, please, please use comments. Explain what you equated it to. You can put the name of the offense from the other state, but tell us what you're equating it to in Minnesota. It's a good way for us to help you, but it's also a good way to keep your worksheet moving forward. When you put a sentence on there, the Minnesota Sentencing Court confirmed all out-of-state offenses. We're just going to push it right on through. That's the statement that we're looking for, is whether or not those have all been confirmed by the district court. I'm going to read this comment. Our writers encounter ongoing issues with trying to request info from other states now that they're charging. Yes, we will usually always check with ICOTS first to see if there are docs there. Sometimes you can find what you need there before reaching out to the other state. That is a good question. And that charging thing, I don't care if this is on the recording. I find that so egregious. We are all criminal justice partners when we're reaching out for that information. And I don't know. I disagree with that 100%. Another comment, verbal confirmation is sufficient to obtain information. And if your court county attorneys are looking for the records, they can pay for them if you don't have a budget. And that's why I sometimes think a prosecutor calling another prosecutor's office, they're going to get that professional courtesy, and they're probably going to get the information for free. I don't know why, but I'm just going to assume that. But well, I think if there are no other, this has been such a good discussion. Thank you all for taking time out of your day to sit with us and talk through these things. As we say at the end of every training, we're not going away. We're still going to be here. And we will do our best to help you. But the one thing that is tough for Devontae and I is when we get an email that says, hey, I have this forgery from Tennessee. What would that be in Minnesota? We are not going to be able to help you. First of all, how many forgery offenses are there in Tennessee, et cetera, et cetera. So when you think about calling us for assistance, make sure you have something like a statute number. Make sure you have something like the name of the offense that we can work together through Google and find it. And calling us on Teams so that we can share the screen and look together is also a good thing, another way to work through these. But that I think that would be all that I have to add. Devontae, did you have anything that you wanted to add?
No, I don't have anything to add. I think that was a wonderful lunch and learn that we did. I think, yeah, Q&As are very productive. I think moving forward, when we start back with our regular Q&As, I think we should do like more regular lunch and learns. I think we should have Q&As at the last 15 minutes of each session. But yeah, I'm happy to hear that it was helpful for everyone. Thank you, Tammy. I think you're the MVP. You helped everyone out with that information. So I appreciate you for that.
You're welcome.
Yeah.
I did send out to the people who asked, I sent out the packet, and obviously the email is in the chat. But if anybody has any information to add to that, I welcome any emails on that so that I can update it too. So
I love that.
I don't know. I like to be able to look at documents to see what I'm doing. So
yeah.
I hear you. Well, thanks, everybody. Thanks for sticking with us again through another Lunch and Learn. We did not do any CLE credits for this one since it was really hard to figure out, what we were going to be talking about. But if you need any confirmation that you were in attendance, we do have attendance lists. So if you need that for your supervisor, for any training credits you need, let us know, reach out. Otherwise, we'll see you back here in a month for next month's Lunch and Learn on enhanced offenses. I think that's it. I thank you so much. Enjoy the sunshine. Bye.
All right. Bye, everyone.